Shockingly, I'm not going to disagree that Citizens United is wrongly decided on a free speech basis. I think the reasoning that associations have the right to speak, corporations are nothing more than a particular type of association of people, and therefore the people in the corporation should be afforded the same rights, makes sense. But I am going to raise something for you that I hope you will think about as we go forward as a policy decision having to do with how we treat corporations. Justice Scalia, in his Austin dissent, says that it's rudimentary that we cannot impose upon the First Amendment rights of corporations. And I would submit to you that that is not rudimentary at all, that begs the question. Corporations are creatures of the state. And if you go back to the roots of the language that establishes the principle that corporations are people, as Brad said, using words in shorthand for certain legal rights and responsibilities, you will find that consistently through the first part of the 20th century, the issues that were being addressed were property issues, were equal protection of the law issues. And these are items that in a constitutional context have to do with the fundamental functioning of corporations in a developing capitalist society. Now, does that mean that there are certain things, certain rights that corporations, simply because they are treated as people for some reason, do not have that are equivalent to natural people? And the law has been very well established that there are certain constitutional rights that corporations do not have. They do not have the right to avoid self-incrimination, for example. And I would just submit to you that since corporations and every limited liability organization in existence, not just corporations, here we use corporations as shorthand for an entity that but for a specific statutory authorization by the state is granted certain privileges in order to exist and do businesses, to submit that their position is the same as a natural person vis-a-vis these types of interest is a serious fallacy, because we are in a position where, as the Bloody Court, which is repeatedly cited in Citizens United, says, where if the actions of corporate funding were to raise the issue of confidence in the electoral process on a fundamental level, it would present a question that could be resolved that as something within the scope of legislative authority to regulate the corporations. And while if you frame it as a free speech issue, can these bunch of people get together and say whatever they want to? Okay, I'm radically in favor of free speech. Am I in favor of Procter & Gamble being able to use its capital to fund free speech? I say that's something that we as a society have the right as a policy matter to decide that is not settled as a matter of constitutional law. That we can say, if you're going to take the privileges that we afford you, perpetual life, limited liability for your owners, governance structures, special tax treatment, then we're also going to impose on you certain obligations and limitations that come paired with those abilities that are only granted as a matter of statutory authorization. And I think that's consistent with the law prior to Citizens United. Citizens United is one of the very, and he referred to it as not controversial part of the decision because it's glossed. Because the court simply says, it's been true for 150 years that corporations are persons. But it is a controversial decision, and that's the policy decision that we have to deal with as a society. What is the obligation of corporations to participate in society responsibly? And I believe it has far broader implications than merely this particular application of it. And I mean, you know, can we impose on corporations the right to act not just for their shareholders' benefit, but for the good of the society as a whole? So when the board of directors makes decisions, they have to take into account the environmental questions, the labor questions, the impact on the society as a whole. Can we do that? Now, I'm not saying that we can resolve today what the right policy outcome for that is, but I would submit to you that if we can abolish the corporations, we can limit their powers and require them to take actions that we could not require individuals to take and prohibit them from doing. And that's just a fundamental thing that arises by how they come into existence. And so that's what I want to give you about my reflections on Citizens United. And I prepared for this for about 2 hours because I really didn't know I was doing it until Tuesday, okay? And it gave me a good reason to read through Citizens United, and I'd urge you, if anybody how many of y'all in here have actually read the opinion, and how many of y'all, good, that's good. How many of y'all followed up with Bilotti and Austin and the earlier railroad cases from the end of the 1800s? Okay, there's the law professor in me coming out. If you don't go back to the precedents, if you simply accept these pulled cites that any court uses in the way it relates what the law is, you can't understand the context of what's going on and what the implicit limitations are on what they are saying. Now, was Austin rightly decided? I don't know, okay? I mean, I'm not a con law scholar. Was Bilotti correctly decided? I would point out that with respect to Bilotti, it involved a referendum on income taxes in Massachusetts. And the court said, no, you can't have a test about when corporations can speak. And this was a very specific statute intended to preclude corporations from spending money to affect the outcome of the referendum on whether or not Massachusetts could have an income tax. As is recognized, we clearly can impose limits on people in how much they give to campaigns in order to avoid the appearance of corruption or actual corruption. And so the thing that really I would urge you to take away from my very short comments here about Citizens United is think carefully about this question of how we create and regulate and require responsibility from entities that are statutorily authorized. And think carefully about the particular generalization of words without great care about whether that word is being used as a term of art and being all-inclusive, or whether it's shorthand for a concept and a policy consideration that has to be taken into consideration and taken into account as decisions are made. Your first one. I repeatedly say to people, if everybody donated $10 in 10 hours to campaigns, to even one campaign every election cycle, all the money in the world wouldn't make any difference whatsoever. And that ties back in, though, to the underlying rationale in Bilotti and Citizens United, where if you get that kind of disproportionate participation that's based on economics, you do start getting exactly that kind of attitude about the efficacy of people's participation in the political process. And in Texas, we typically don't even have 50% of the registered voters vote, much less a high percentage of those who are eligible to voting. So I think that's a real problem. Well, and I would agree. I would not give the government power to censor private communications, no matter how funded, as long as it's individual funding. I mean, but I would come down on the side of saying it's not constitutionally impermissible to say corporate entities can't, as an entity, speak. And that's just and yes, you want a broad marketplace of ideas, but unless you impose on those corporations correlative responsibilities to society, then they have a very focused kind of interest in the way they participate in process. And so there was a question over here too. Oh, well, I'm just going to say, in the absence of legislative authorization, corporations would not exist, okay? And if you go back to the history of corporations, which you may know, that originally it took a special act of the legislature in order to create a corporation because they were deemed so dangerous. And it was only as modernization took place in the mid-20th century that we enacted corporate codes that in effect made it a ministerial act, an administrative act for the state to create the corporation on application of an individual. And yes, it requires an individual action, but without state authorization, limited liability, perpetual entities do not exist.